Attorneys for Karen Reed are now asking for some charges against her to be dismissed. The judge declared a mistrial after the jury could not reach a verdict on whether Reed rammed her police officer boyfriend with her SUV and left him to die. Now her defense team says trying Reed again on 2 of the charges could constitute double jeopardy. ABC's Ariel Reshef has the latest on that story.
Hello, legal-minded friends. I'm Karen Cole. If you are not familiar with the Karen Reed case, you should check out my playlist, as this case, in my opinion, is a miscarriage of justice. So, what is the shocking reveal by the prosecutor in their latest notion of disclosure? The Commonwealth respectfully submitted a post-trial notice of disclosure, following the defense submitting a motion to dismiss after hearing from members of the jury that they did unanimously agree to acquit Karen Reed on charges 1 and 3. They were rightfully concerned. Let's hear what the Norfolk District Attorney immediately decided after the mistrial.
I'm declaring a mistrial in this case.
There you have it. The judge in the Karen Reed murder trial today declared a mistrial after jurors were unable to reach a unanimous verdict.
Moments later, we saw Reed embrace her father right there, perhaps a moment of relief. But this case is far from over. The Norfolk County District Attorney's Office says they do intend to retry the case.
I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg, because I'd like it to be with your schedule. Then we need a trial date, and we need a final trial conference. So I was thinking on the motion to dismiss, can we do it a week from Friday? It would be for oral argument only.
From the defendant's perspective, yes, Your Honor.
All right, I think that's August 2nd, Mr. Clerk.
I'm going to be out of state. I return on August 3rd.
Okay. August 9th? Are you available? 2 o'clock. Are you available, Mr. Weinberg, on August 9th? Mr. Lally, is the Commonwealth available on August 9th?
Yes, Your Honor.
All right, so that's for oral argument only.
At the status conference hearing, a new trial date has been set for the 27th of December 2025. Let's listen to the judge in this status hearing and see what she assumes.
Whatever I end up doing on the motion to dismiss will be appealed. In an effort to make sure we have plenty of time, I would like to schedule the jury trial on January 27th.
And you heard the judge. She assumes that whatever she decides at the motion to dismiss hearing, it will be appealed. Those arguments have been set to be heard on the 9th of August. So, after the jurors reached out to the defense with shocking information that they were not deadlocked on all 3 charges, that in fact they had agreed to acquit on 2 out of the 3 charges, but because they didn't know the process of submitting this information, they had not completed the verdict slips. So, the defense is right to be concerned about Karen Reed being retried for a crime on which she was previously acquitted by a jury. What is so shocking about the prosecutor's latest reveal? To answer this, let's go back a little bit.
And I want to bring in ABC News legal contributor Brian Buckmeyer for more on this case. Brian, the defense claims a juror contacted them saying that the jury had agreed unanimously that Reed was not guilty of 2 of 3 of these charges, the second-degree murder charge and the leaving the scene of an accident with injury or death. If that's true, why weren't these verdicts read in court?
So it's a little bit about the form of which a hung jury kind of operates. The verdict form wasn't filled out. We got a mistrial or a hung jury because of a note that was given to the judge. The judge read it out, and I'm not going to be as pointed as the defense attorney and say that she made a mistake, but maybe hindsight being 2020, she might want to do it differently going forward, but read that note that the jury was deliberating and couldn't get to the point of a verdict. And this was the third note of its kind. And from that note, the judge said, all right, I'm declaring a mistrial. But the charges weren't really properly articulated as to which one the jurors were hung up on. And that's what the argument the defense is making, that there should have been a greater exploration as to what the hang up was, which charges, if any, they might have been able to come to a consensus with, and where there was a hung jury.
Because you can have verdicts on some of the charges and then have a hung jury on others.
Absolutely. You can be acquitted of one charge, guilty of another, and hung on a third. Or you can say that you're having difficulty with all charges, and the defense's argument is, well, you need to explore a little deeper as to what those difficulties mean. Because what they're finding out now is one juror reached out to them, two separate individuals reached out who talked to two separate jurors, so 3 jurors in total, said, hey, murder was off the table. And even the third one might have been off as well.
Now, the defense, because of this, is asking that these 2 of these 3 charges be dismissed or that they get a voir dire of the jury. So how does that work? What are they hoping to accomplish, and what do you do now?
Yeah, so the first thing is the prosecution is going to make the response. The judge will decide based on their responses. What it looks like from the Massachusetts case law is that it's the prosecution's burden to prove that there was a manifest reason for a mistrial. But it's going to be a very big hurdle to get through that initial step of saying we need to voir dire the jury, because to speak to a jury after their verdict is almost sacrosanct. We don't really pierce that veil, so to speak, unless there's a really big issue, but this could be a very big issue. And so if they do get past that threshold and have that voir dire of simply just the judge or the defense attorney in the presence of everyone speaking to the jury one at a time, and it does come out that there were 12-1 to acquit on 2 of the charges, the defense could win and ultimately have 2 of the charges dismissed and only be retried on that manslaughter.
All right.
Let's go back a little bit to the 8th of July, 2024, when the Commonwealth responded to the defense's motion to dismiss. Would the Commonwealth change their mind if jurors contacted them? In this response that was submitted on the 12th of July, 2024, basically they said that the defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation, meaning it is not worthy of further investigation. Let's read the latest notice of disclosure by the Commonwealth. On Sunday, July 21st, 2024, notice he says that it was on a Sunday. Anyway, the Assistant District Attorney Adam Lally received an unsolicited voicemail on his office phone line from an individual who identified themselves as a juror by full name and seat number. This individual stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3. So, do you think the prosecutor let the defense or judge know before they were in court for this status hearing on the 22nd of July? Now, would there have been time to let the parties and the judge know? Because I thought the hearing was in the afternoon at 2 p.m. When I worked for the county solicitor's office, the first thing in the morning, what you do is you check your phone messages and emails. And if you are in court that afternoon, you make darn sure there's no urgent messages dealing with the case that you're going to be before the court for. And if you're expected to be at court in the morning as an officer of the court, you just have to ensure you've left yourself enough time to do these vital checks. So was the hearing in the morning or was it in the afternoon? I can't remember. Let's find out.
Judge 22117 versus Karen Reed. Can I have counsel identify themselves? I overcome.
Analyse for the Commonwealth. Good afternoon, Your Honor.
Good morning. Good afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Mr. McLaughlin.
Good afternoon, Your Honor. Martin Weinberg, on behalf of Karen Reed.
Good afternoon, Mr. Weinberg. It's nice to see you.
Good afternoon, Your Honor. Dina Giannetti for Karen Reed.
Good afternoon, Ms. Giannetti. Good afternoon, Ms. Reed. All right, so the case is scheduled today for trial assignment, and what I'd like to do is to get 3 dates. I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg.
Yep, closed captions confirm the status hearing was in the afternoon at 2 p.m. Did you hear everybody saying, good afternoon, good afternoon, good afternoon? Even the judge said good afternoon, but did you hear a Freudian slip before she said good afternoon? She said good morning. Here, if you didn't hear it, let me do the replay.
Analyse to the Commonwealth, good afternoon, Your Honor.
Good morning.
Analyse to the Commonwealth, good afternoon, Your Honor.
Good morning.
Okay, you might be thinking, why is this important, Karen? Everyone can get the morning and the afternoon mixed up. It's an honest mistake. It's not a Freudian slip, but I find it hard to believe that Adam Lally, upon returning to work Monday morning before this hearing, did not do his vital checks and did not tell the judge in the morning about the voicemail he received from the juror. And maybe this is why the judge had a Freudian slip. She was thinking about what she had been told about in the morning. What do you think? So now I'm still reading from the disclosure. On Friday, the 26th of July, 2024, so that's a couple days after the status hearing on the 22nd of July, the Assistant District Attorney, Adam Lally, received another unsolicited voicemail on his office phone line from the same individual who stated, ... can confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3, guilty on manslaughter charges, ... on the lower level manslaughter charges. So we're continuing on with this disclosure. The Commonwealth did not respond to this individual, as the Commonwealth is ethically prohibited from engaging in discussions about jury's deliberative process. Nonetheless, on the 16th of July, so that would be, my point is that it was before the 22nd status hearing, the Commonwealth responded to the emails. Again, my point is that it's plural, so that means there was more than one juror. They responded to the emails by stating that the Commonwealth would welcome the opportunity to discuss evidence or the Commonwealth's case. However, they are ethically prohibited from inquiring as to the substance of the jury deliberations. That would include their individual or jury's collective thought process, the content of their deliberations, or the reasons for their decisions. They go on, it was further explained that the Commonwealth could not promise confidentiality and that the substance of any communications may necessitate disclosure for the defendant or the court. Now I find this interesting. The last paragraph says that all 3 jurors declined to further communicate with the Commonwealth and provided no information about the jurors' purported votes. Okay, see if you can follow my thinking here, because this is interesting. The defense filed their affidavit in motion to dismiss with the court on the 8th of July. They said they were contacted on the 3rd of July, so that's like a week before they write their motion. So I want to know what's going on. When did the jurors write to the court? Because Lally tells us when they received the phone calls, but they didn't say when they received the emails. They did, however, say they responded to the emails on the 16th of July. I want to know when the Commonwealth got these emails. When did they receive them? Was it the same time as the defense? Or did they contact the defense because it took so long for the Commonwealth to respond? Or did the defense say, look, you got to contact the Commonwealth? And they said, yeah, I already left a phone call. And then they said, write an email. Well, when you find out what the defense did on the 18th of July and what also happened on the 18th of July, this could give us some of the answers. Let me know if you think it's a coincidence. Let me play you some of the news so you know what happened.
Now, according to an affidavit filed by Juror Doe, she writes, quote, "It was an honor to serve on the jury. It also was a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to anticipate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family." Now, Karen Reed's defense team also filed another motion today saying that a fifth juror in this case has come forward saying that they did reach an agreement, a verdict on 2 of the 3 charges they were asked to deliberate on.
So, do you think it's a bit of a coincidence that the defense came up with a 5th juror that has come forward to say how the jury decided, and yet the Commonwealth got an affidavit from a juror who was surprised that their deliberations were being divulged and they didn't want their information and identities to be public? I'm also starting to wonder if the juror that came forward to say they don't want their information to be made public is because they're concerned that there will be a voir dire of them. And do you remember with the Alex Murdaugh case, they had to voir dire the jury and they did it in open court where we could see them. So I'm kind of wondering if they were told there's probably a good chance that there will be a voir dire. And so they've come forward to say they don't want, their identities to be known. Let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.